This week, in a nearly unanimous decision, the U.S. Supreme Court declared Florida's death penalty system unconstitutional, changing a 40-year judicial process. The state is one of only 3 that grants judges the right to impose a death sentence as opposed to juries, which is stated in the U.S. Constitution. Justice Sonia Sotomayor wrote, quote, "The Sixth Amendment requires a jury, not a judge, to find each fact necessary to impose a sentence of death," end quote. Having the second highest number of inmates on death row in the country, how will this affect the hundreds of Florida inmates awaiting execution? Joining me to discuss this and more, we welcome Natalia, legal director for the American Civil Liberties Union of Florida and former staff attorney in the 11th Circuit Court of Appeals in Atlanta, and Charles Zeldin, professor in the Department of History and Political Science at Nova Southeastern University. Thank you so much for being here. Let's address first the case that got the Supreme Court to sort of overturn how things work here in Florida, and then maybe we can launch into a philosophical/political debate about capital punishment, qua capital punishment, and whether or not we should still be operating under this form of justice. Nancy, so let me start with you. Can you talk a little bit about the Hearst case, which is the case that prompted the Supreme Court to overturn how we do things here in Florida with respect to the death penalty?
Yeah, so Mr. Hearst was convicted of a capital crime and sentenced to death, as we know, and the jury recommended by, I believe, a 7-5 vote, recommended death. And in this case, the judge ultimately found the factors that would support the imposition of such a sentence. And the issue that was before the Supreme Court in terms of whether or not a decision that was not unanimous from the jury, that was only advisory to the judge, indeed was unconstitutional.
So the lawyers for Hearst filed the case before the Supreme Court?
It was a challenge from Mr. Hearst, yes, challenging his sentence as a violation of the Sixth Amendment because the decision to impose the death sentence was not, number one, unanimous from the jury, and also was advisory only. And again, that it was the judge who ultimately decided whether or not the facts existed.
So why did it take so long for people to realize this was not the way it was supposed to work?
Well, many people have realized this for decades, and in fact, the legislature in Florida has been on notice that this sentencing procedure is unconstitutional. Unfortunately, it's taken a long time for the U.S. Supreme Court to reach this decision, and so for us, the Supreme Court's opinion was very long overdue.
Right. So, Charles, sort of, how do you see it? I mean, it's getting support on both sides of the aisle. It's pretty bipartisan.
It is.
What are the political optics, I guess, maybe at work here, or
in this case, it's on the right side in the court for technical reasons, in terms of the reading of the Constitution. It's sort of a textual reading of the Constitution.
Except Alito was the only dissenting opinion here, or he was.
Yes.
Why did he dissent?
Because he generally dissents on any limitation of the death penalty. He believes that it is a right within the states to choose to execute those who have broken the social contract.
And how they want to go about implementing that process is a state right.
Essentially a state right.
Got you.
The state's argument in this was that the important part in terms of the jury is in the first phase, the phase in which you declare that somebody is guilty of a crime that is available for the death penalty. That is known during that first phase. And there, the jury is the sole determinant of guilt or innocence. The second stage, the state argues, is more almost administrative, in which the judge and the jury are working in tandem and collectively to come up with an understanding of the situation as to whether to apply the death penalty or not.
Right.
And so they feel that the judge should be an equal player in this with the jury, and that was the argument they made in their brief to the Supreme Court.
Interesting. So what does this mean for convicted felons currently sentenced for death? There's a case coming up in February, is the next imposition of the death penalty, right?
That's
here in the state of
correct.
Florida.
Mr. Michael Lambrix, who's being sentenced, whose execution, I believe, is scheduled for February 11th. And the Florida Supreme Court, in fact, just this week after Hearst, has now ordered both parties to brief the issue of what impact, if any, Hearst has on their ultimate decision whether or not to uphold his sentence. We believe that it has a tremendous impact, not only
we being
the ACLU as
why?
well as many opponents of the death penalty, because again, in Mr. Lambrick's case, it was a situation in which the jury's decision was not unanimous, in which the judge was the ultimate decider as to whether or not death should be imposed. And we first case is Mr. Lambrick's case, as well as not only the cases that are currently on appeal involving the death penalty, but as well perhaps as the...
So our current state attorney, Pam Bondi, though, is not requesting a stay for the sentencing, right? In other words, she does not perceive this ruling as retroactive, as applying to cases prior to this ruling. So this is now law moving forward, but anybody sentenced before it is sentenced before it, right? It's not going to affect them, or?
Well, we're going to find out what
find out.
Attorney General Pam Bondi believes today, because her brief on the impact of Hearst on Mr. Lambrick's case is due today.
Right. This is Friday. As of today's
As of
taping,
today,
right.
January 15th.
Right.
However, there is a question about retroactivity. The Supreme Court has made it clear that states, the Florida Supreme Court in particular, does have the discretion to apply the Hearst decision retroactively to the almost 400 cases that are currently in which the death penalty has been imposed in Florida that are, at stake right now. And so there is legal support for application of the law retroactively. And so we believe that given the significance of Hearst, that there at least should be a moratorium on the death penalty or imposition of death sentences until the legislature can, number one, rewrite the sentencing code, and then number two, there's an opportunity to review those cases to make sure that they comport with the Supreme Court's decision.
I don't know, it seems like prudence is the best route always. When in doubt, stop and think critically about it. I don't know,
when it
Charles,
comes to the death
what
penalty,
do you
that's
think?
not the norm. The states generally have been, especially in the South, have been very aggressive in defending their rights to execute criminals. And
what's the argument for that? Apart from just a cultural thing, is it just a cultural, philosophical?
On their justification
bias?
is these people have broken the law, done heinous crimes, and they deserve to die. There is, through the eyes of many, a racial and or socioeconomic bias here. Most of the people involved are people of color or they're poor. And in fact, back in the 70s by Justice Brennan and Justice Mitchell, that essentially why you can never have a just death penalty process because of human nature and the biases we have as to who is dangerous and who isn't.
Right.
But the states have just been very aggressive, saying this is our right to do this, and generally they'll keep pushing as far as the law will allow them until the courts push them back.
Right.
So I expect that the state's going to argue that this was a purely in the future, no retrospective nature to it, and then it'll be up to the Supreme Court of Florida to determine what to do. That court, on the other hand, I could see at least going with moratorium and possibly even arguing retroactivity.
Right. It just raises the interesting, again, moral debate about capital punishment itself, which is worthy to reconsider from time to time. On the one hand, you have the argument that justice must be done, and anybody committing a punishment of this nature deserves just retribution, which is death. On the other hand, we do have a flawed legal system. My wife has me addicted to Making a Murderer, right? And you can obviously see, the potential for human error in the whole process. So why not guard on the side of life or safety?
That was the position of Brennan and Marshall. And Brennan, I saw an interview that he did in the 80s where he said, I always vote against the death penalty. I think it is simply inherently impossible to do it in a just way, with due process. And
Is that the stance of the ACLU?
Yes, we believe, number one, that it is improper to impose the death sentence. We are categorically opposed to the death penalty. Number one,
Universally,
in every case, because as you've indicated, our society as a civilization, we have evolved. And that's why Florida is one in the United States, one of even fewer societies that actually even have a death penalty sentence as an option. But then also, number two, to the extent that is not persuasive enough, as you indicated, the racial, the socioeconomic disparities in the imposition of the death penalty. The fact that if you are a black defendant and you have a white victim, that you are more likely to get the death sentence than a white defendant with a black victim. That inherent bias, racial bias alone should be sufficient to show that the system is so flawed and the stakes are so high that it's just not a proper
Again, not to quote
sentence.
Netflix and Making a Murderer, but the cost of civil defense too is astronomical. So really to receive a fair trial by jury is difficult, relative obviously to the costs that you would incur needing great lawyers, apart from, not to say public defenders aren't, but you can see the inequity and the disparity, right?
And in states like Texas, where the public defender is simply a lawyer that is hired to do the case, there have been examples of lawyers who were not particularly competent.
I don't want to appear too one-sided here. I think maybe perhaps the other argument is that the death penalty does deter crime, that the fact that we have the death penalty does in some way deter heinous acts. Is there any research or data to bear that out?
There is research on both sides, but at least the parts that I've read, the general consensus is it actually doesn't serve as a particular deterrent. That when people act in a certain way that would be justified a life sentence or the death penalty, they're usually not thinking about, oh, if I do this, they're going to kill me. And as a result, where's the deterrence?
Yeah.
And we also have to think about the factors that contribute to someone getting caught up in the criminal justice system, especially when you look at juveniles, our poor educational system, our eroding family structure, the fact that our sentencing code is such that you can be penalized for acts that at one point weren't even subject to criminal prosecution. And so we've just moved in this direction of criminalize and lock up people instead of trying to really fix our society in such a way that the level of criminal activity actually lessens.
Right. So back to this issue then and what this means for Florida moving forward. Are there any bills before the state legislature to address now? Everybody's sort of freaking out in Tallahassee with respect to what this means for criminals on death row. Are there any bills you were mentioning before the show that there are currently?
Yes,
two?
we're aware of at least two bills: House Bill 157 and its companion Senate Bill 330, which would address the issue of the jury being the ultimate fact finder to support a death sentence, and it also addresses the issue of having a unanimous jury decision as to whether or not death should be imposed. Something that Hearst was that the Justice Sotomayor did not address in her opinion, but was definitely before the court. We wish that the court had also addressed that issue, and we think that this is the legislature's opportunity to get in front of that topic so that we are not here a few years later with another Supreme Court decision on the issue of unanimous
Charles, what do you
jury.
think of those bills? Do you think they seem reasonable or?
Well, reasonable, yes. Although my own preference would be to have a bill that simply ends the death penalty.
Right. Doesn't the unanimous requirement, the unanimous vote on the part of the jury in favor of the death penalty, make it pretty damn difficult to?
Well, again, there are plenty of people who are on death row in which a jury unanimously ruled that they should receive the death penalty. Remember, one of the questions that you're asked in a death penalty case, especially in the punishment phase, is, are you willing to impose the death penalty? So anyone who's opposed to the death penalty for moral, ethical, or policy grounds is actually removed from the pool for cause.
Wow, I didn't know that.
So the jury pool as it is already not necessarily skewed to do it, but skewed with people who can conceive of doing it. And I think most people would simply assume that of course it's unanimous. Aren't all decisions of the jury supposed to be unanimous? And the answer is not necessarily, in a whole bunch of levels. And while it might make sense in a civil case where what is at risk is property, in a criminal case in which the freedom and or life of an individual is at risk, to expect anything less than unanimity from the jury, I think is is wrong, and I suspect that most people would agree with that sense. Even if they're in favor of the death penalty, they would say, but at least have the jury be unanimous in saying this person deserves the death penalty.
Right. Does the ACLU support the current bills before?
We're still under examination, but those two elements of the bills, for sure, we would be. But I would agree with the professor that we believe that the best bill would be to end the death penalty. And even having a unanimous jury in support of death still doesn't address the fact that we have one of the highest, I believe, #1 in terms of exonerations and people removed from the death row because of errors, whether it be on the prosecutor's side, insufficient evidence ultimately determined by a higher court. And so again, with the stakes so high, someone's life on the line, the death penalty, especially with this flawed legal system, is just not the right way to go.
Right. Last question for today. Does the ruling in any way have any impact on any other states? Will this affect any, like Alabama or Texas or Louisiana, or I don't know, does this have any impact anywhere else? Or no?
Absolutely. This is the law of the land now, that if you want to have a death sentence imposed, it is the jury in every state that has to be the ultimate fact finder. So absolutely, this case has a national impact.
So are any other processes in any other states going to be overturned?
I think there's two other states that follow a similar pattern to Florida.
Oh, okay.
So most states do leave that in the hands of the jury.
But I believe Florida is the only one that does not require unanimous jury decision when it comes to imposing the death sentence.
Interesting. I think it's Alabama and Delaware that are the other two that are somewhat like what Florida has done, right? Charles, closing thoughts on the matter. Anything else you want to add to the discussion?
It's good to see the Supreme Court ruling on this. There had been cases going back 20, 30 years where the court has accepted pieces of the Florida system, and the court and in fact, Florida was arguing stare decisis. This is the way the rule is. Just keep doing what you said we could do. It's good to see that the court has looked at it as a whole piece and said, no, this just doesn't fit the Constitution.
Right. Fascinating sort of both political, legal, ethical discussion, and I think really the Florida voters and the viewers should really sort of look into the merits of the death penalty and perhaps write to the state legislature expressing their opinions about how we impose justice in the state of Florida. And so thank you for contributing to the conversation. At least this is what the purpose of the show is, to cultivate sort of this dialogue and conversation about issues that matter. Thank you all again for joining us. Remember to like us on Facebook, Issues with Helen Foray, and follow us on Twitter at WPBT2 Issues. I'm Henry Mack. Thanks so much for watching. The Department of History and Political Science at Nova Southeastern University. Thank you so much for being here. Let's address first the case that got the Supreme Court to sort of overturn how things work here in Florida, and then maybe we can launch into a philosophical / political debate about capital punishment, qua capital punishment, and whether or not we should still be operating under this form of justice. Nancy, so let me start with you. Can you talk a little bit about the Hearst case, which is
Supreme Court in terms of whether or not a decision that was not unanimous from the jury, that was only advisory to the judge, indeed was unconstitutional.
So the lawyers for Hearst filed the case before the Supreme Court?
It was a challenge from Mr. Hearst, yes, challenging his sentence as a violation of the Sixth Amendment because the decision to impose the death sentence was not, #1, unanimous from the jury, and also was advisory only. And again, that
act necessary to impose a sentence of death. End quote. Having the second highest number of inmates on death row in the country, how will this affect the hundreds of Florida inmates awaiting execution? Joining me to discuss this and more, we welcome Voodoo, legal director for the American Civil Liberties Union of Florida and former staff attorney in the 11th Circuit Court of Appeals in Atlanta, and Charles Zeldin, professor in the case that prompted the Supreme Court to overturn how we do things here in Florida with respect to the death penalty.
Yes, so Mr. Hearst was convicted of a capital crime and sentenced to death, as we know, and the jury recommended by, I believe, a 7-5 vote, recommended death. And in this case, the judge ultimately found the factors that would support the imposition of such a sentence. And the issue that was before this
This week, in a nearly unanimous decision, the U.S. Supreme Court declared Florida's death penalty system unconstitutional, changing a 40-year judicial process. The state is one of only 3 that grants judges the right to impose a death sentence as opposed to juries, which is stated in the U.S. Constitution. Justice Sonia Sotomayor wrote, quote, "The Sixth Amendment requires a jury, not a judge, to find each fact